units. The letters were sent out, demand was sent that they contact the attorneys to cure the matter. The parties who were so notified, one complied very satisfactorily, we were very grateful. Two others have not. They did not reply to the attorneys, and the matters were ready for suit to be filed at the request of the board. The request that we let the attorney know if suit should be filed came at approximately the same time as we were preparing for our annual meeting and the election of officers. The matter did not go to suit at that time because of the pending election, and it was expected that the new board would follow through and hold up the regulations and the condo docs pertaining to limitation of ownership. The new board evidently does not feel it wishes to pursue this, but that does not mean that the previous boards failed to try to enforce these regulations. So your premise that they are null and void because they've been not selective enforcement, whatever you want to call it, is absolutely untrue.
Thank you. So it's clear, the law requires not letters be sent, but actual legal action be filed in the time frame that you're referencing.
The year has not expired.
It's my understanding that there are individuals that are in violation of this particular restriction for many years, not just a single year, and that there has been no republication of this particular restriction during all of that time. Which means that, excuse me, I didn't interrupt you, ma'am. So if you would do me the same courtesy, I would appreciate that.
If you'll allow me to point out again when you're finished that your information is incorrect.
It's not a conditional request.
Oh, it's only one-sided?
Wait, she wants to clarify so you could respond properly, that's all.
She made her statement, I'm responding to her
But
statement.
you misunderstood
You're
according to
bringing
her.
up another matter of previous years, and I'm telling you
I'm
that
bringing
in
up
previous years we
what,
also
it's
attempted
a global
to
fact.
enforce this restriction.
I'm unaware of any litigation prior to your indication of the request to file suit this past November, December on these particular issues that have been filed on this particular issue in the last 8 or 10 years. And the restriction was in place for longer than that, yet the violations are in place for well beyond that. If suit was filed, as requested at the end of last year, there's very likely, based on what I'm aware of, that there'd be a valid defense of selective enforcement by those individuals based upon the fact that there are others that are in violation that have not been brought before the courts, and that the association would be unsuccessful in its enforcement efforts. That's the point. Not that a prior board may not have tried to do anything. The prior board had good intentions and certainly was trying to do the right thing, but just was not legally able to follow through with it.
Well, that stinks.
Yes, that does stink, doesn't it?
Anyone else? Okay, now the board will speak on this issue. Stuart, you want to speak on this issue about unlimited ownership of apartments and 25% cap? But on the issue of whether, on the issue of whether we are allowed to do this, not on what the ramifications are.
Number one, Francis is 100% correct, and I will correct Mr. K. In the year I think it was 2004, and I've got the case, when Mort Cater was president, he went to court against a unit owner for having more than required 4 units. The unit owner did not appear. The judge voted on his behalf and said you must start liquidating, and I have a copy of the case. Anyone who wants to see it, give me a call, I'll make a copy, and I'll hand you it out. So don't say no action has been taken. Plenty of action was taken. That doesn't mean it's not a fact, Robert. I got the case.
Well, default, that doesn't necessarily mean.
Well, Robin, I can't argue points of law against you because I'm not a lawyer. You already took our lawyer out of here to argue with you. So let's not get involved with that. There is a case. I've got the case. So I want to just clarify that what Francis is saying is correct. We didn't just sit with our fingers crossed. She took action. Mr. Cater, who was the president at the time, took action, and the only reason he couldn't follow it up is he resigned. He's no longer in the village, but I have a copy of the case. Anyone that wants it, contact me. I'll give you a copy of it.
Yeah, you can send it to me too. Yeah, you can send it to me too. I'll distribute it to the board. Okay, anything else from the board? Doug?
Yes.
You got a mic there?
Thank you. That action that Stuart spoke of was against me, and when I threatened appeal based on selective enforcement, the board at that time dropped the case because they knew they were going to lose. So just to clarify that.
Well, Doug, you pay your bills, good for you. Come on, I pay the bill already.
Right, now wait a second. No, you don't have to answer him. You said you have something, deliver it to the board and the attorney, and then we'll follow up. No, I'm not recognizing you.
Okay.
Okay,
You operate. You don't want the truth to come out. We know that.
okay. There's no more conversation from the people here about the unlimited ownership of apartments by any party nor adhere to a 25% cap. We'll go on to the next one. This is on, I would appreciate down that end of the table if you guys would stop whispering because it's very distracting.
I have a point of clarification.
No, we're on the next issue already. The next issue, the next issue is
Clarification.
I can't hear you.
Does that mean that we can now buy as many units?
No, that issue's over. We just closed that.
Is that what it means?
That issue is over.
What is the point of clarification? A point of order? Anything you want to call it?
No, we just asked and you're getting up. Now you're getting up after we stop and now you want to ask the question.
It'd be a lot easier just to answer.
Go ahead, ask your
Just
question.
answer the question.
Go ahead, ask the question.
Does that mean that we can buy any number of units and rent any number of units we want without restriction at this point in time, Mr.
I'll read it
Hay?
again. The association cannot restrict the unlimited ownership of apartments by any party nor adhere to a 25% cap on rentals. Now, that's not clear enough. I said it 4 times.
I want you
Okay.
to say it.
I will go on to the next issue now. The next issue is the restating of the 1995 rules at board meetings, which is going to restrict to some degree the unit owners shouting out, raising up, arguing on the floor. That's going to stop. You're going to be able to, at the meeting, speak on any agenda item. Under normal conditions, if it wasn't tonight, we'd have you send in a written request as per these documents to the board when they see the notice posted and say to the manager or the secretary, you want to speak on certain agenda items, and you will be allowed to speak on those, and if you don't sign in, you won't be allowed to speak at all. That's the way the rules read. And that's the way it's going to be, because we cannot have shouting, yelling, fighting here. We've got business to do that's important to the health and welfare, the financial condition of this community. This has got to stop. We've got to talk intelligent, talking nicely to each other, and stop screaming and getting involved and arguing every way you can, even after I say what it is. Okay. Are there any questions from the floor?
Is it going to be only one-sided? Yes, please. What proof do we have that these rules were ever adopted by the board? And what proof do we have that notice was given to the membership as required before the rules went into effect?
Okay. The rule, the You're talking about proof that this was sent to the unit owners? Right. Now, we are restating this tonight. The board's going to approve it tonight, I hope. And then we're going to resend it to the unit owners. And we're going to have a new mailing. However, since the state law requires 7 years, it's a minimum of 7 years that you have to keep a document. This is 15 years ago. These documents are nowhere to be found. In fact, a lot of documents are missing from this office, more than you can imagine. If you'd come by, we'd show you what we've done.
I'm well aware.
Okay, so there's no requirement for us to dig up something from 15 years ago. 7 years is the limit, and we will send it out again shortly to restate it, and this is the way it is. Do not need to prove a certificate of mailing.
What you're saying then is these rules are null and void until you do exactly that you resend it. Because I've got legal opinion that states that since nobody ever heard of these rules, you've got to produce some documentation. Now, you could argue, Robert Kay could stand on his head, but you can't enforce these rules until you do exactly what you said.
If the board chooses to enforce these rules, you have recourse. You can bring a lawsuit, you can go to the ombudsman, and you can do whatever you want. But this is going to be the rule of this community. That's all. I'm not recognize you.
I don't think that was what he was actually saying.
For clarification, what Mr. Wolf has indicated that until the board actually readopts these particular rules, they're not in place, which is correct, and Scott did say that earlier.
No, but he said now that they're enforcing them right now.
No, they're not being enforced right now, has been evident from what's gone on up to this point.
Then I'm in agreement.
Thank you.
Okay, so with that, we are, if no one has any more questions for Mr. Kay, he's been very nice. I appreciate his coming here. Thank you, Robert. And anyone from the board want to say anything to Mr. Kay?
Thank you so much for coming.
I do.
Look forward to seeing you.
I do.
Okay, come on, Stuart.
One question that was asked before, and then I'll find the answer as a board member. I want to know, since the unit owners are entitled to know, and since we are officially broke unless we violate the law by using insurance money, how much did it cost us to have Mr. Kay come here? And then why, since he says he's not afraid, I want to see documentation on who voted for what, since my son, Dov, and I were never consulted on any vote to have Mr. Kay here. We're board members, even though it's a rubber stamp, you had the votes, but the law says we're entitled to vote. And Robert Kay taught me one thing, right? Maybe he taught me more than one thing. I'll give him credit. You cannot pass something verbally or by email and then ratify it at a board meeting. The only exception, and I'm quoting Robert on this, is a true emergency, a fire, a leak, something that requires immediate action. This did not require immediate action. I can tell you when you told it to me, Robert, because I have impeccable notes.
Okay, I think you missed
Thank you.
what I told you.
Well, then tell me
Robert.
what you did say.
Thank you very much. Okay,
Could Mr.
Robert.
Kay clarify that?
That's correct what he said.
Yeah, clarify that.
It's never been my opinion that the board can not make decisions outside of a meeting and then ratify it at the next meeting. In fact, just the opposite. My opinion is that the board can consult among themselves outside of a meeting, can reach decisions, so long as they are ratified at a duly posted meeting as an agenda item.
I disagree with what you told me. I can give you when you said it.
I
I wrote it
believe
verbatim.
I've given written opinions.
okay. Thank you, Robert. Appreciate it. Okay. Okay, now we get on to the good and welfare before we start our meeting. The good and welfare coming before the formal decision-making portion of the meeting. No decisions were made. This was just a statement, an information fact. And now we're gonna have Mr. Frank Mazzio come up and make a statement. 3 minutes, please, Frank.
Gentlemen, ladies, I want to thank you for the opportunity of allowing me to come here to address you. However, I would greatly appreciate if you take a deep breath and kind of relax your mind.
Microphone.
Money.
Wait, use the mic.
There you go. I don't need the mic.
We can't hear you. We can't hear you.
I'm going to tell you exactly what's in the paper, but I want you to have it because I don't want you to forget it. I need the money. I think actually it belongs to me somewhere. Oh, shut up, I'll give you this one later. No, here. No, here you go. Anyway, what I'm saying is my name is Frank Mazzio. I live in the St. Moritz apartment 3F. I bought my apartment for cash. I don't owe anybody any money except Ford Motor Company for about 1.5 years on my car that I bought 3 years ago. Anyway, my complaint is this. You took 3 months of maintenance money, and I was told by the real estate lady I could get it in 3 months. 7 months after living here, I applied for the three months money, and I was told it takes 3 years before I can get it.
Correct.
Anyway, I think that's a little bit unfair. I think the rules should be changed to 1 year, 1.5 years, which would be more in line with being fair. I need the money. I'm supporting a granddaughter who's going to college with 2 children. That $750 will help her. Please pass a law and send me the money as soon as possible. Thank you.
When did you buy the unit, Frank?
Probably June 2 years ago. It'll be 2 years.
Okay, if I remember correctly, I think the association voted in an amendment to the declaration that after 3 years, you would get it back, providing you sent a certified letter to the association after the 3 years, and they would give it right back to you.
Well, I'm asking you to give it back now. 3 years, what do you need it then? You don't
Well,
need it. Use it.
well,
Change the law.
Well, I'm 100% in favor of that for this reason. If Frank's been paying his money, then we have no business to hold it for any longer. If he's been paid promptly, we have no business to hold it because it's not our money. It's his money, it's in an escrow account, it's not gaining interest, and if he doesn't claim it or we don't give it back, it goes to the state of Florida. So this is wrong. Well, the board will take this up, Frank.
Thank you very much.
Okay, take it up at the next.
Frank, I want to answer you. I bought my apartment for cash. My money's in the escrow account, and I'm with you.
Thank you very much.
Frank, I'm in the same boat.
Thank you.
Well, I think that's a good consideration, that if people have been paying and they haven't missed anything, they've got no late fees, and they're here 2 years, reasonable amount of time, we'll find out. It's violating the documents. I don't know, we don't want to do that, but we don't need the money. I wish we didn't have that escrow account, because we have to keep track of it. No, wait a second, you're not up. Oh, you want to talk on this issue? No, is it on this matter? Okay, go ahead.
Was this escrow account in effect 20 years ago?
No,
Was not.
no,
So there's not money is not in escrow.
no. Okay, the next one is Jerry Miro. 3 minutes, Jerry.
How come you only told me?
30 seconds
3
up,
minutes.
hurry.
You have the timer down there?
Wait, that's a
No, 3 minutes.
3 minutes.
Well, you folks have seen what's going on here tonight. And, you know, you have no real input. Everything is in this direction. Some things good, some things bad. But at some point, it crosses the line. And I think these folks may have crossed the line, or some of them. For example, this evening, or yesterday, I turned in my notice to video the meeting tonight, and the manager told me I couldn't do it because somebody else had done it first, and the board was only allowing 1 taping per meeting. course, I said, I'm taping anyway, call the cops. Okay, and I asked who was doing the taping, and I was told Mr. Tersigny, the vice president's husband, and our secretary was doing the taping. And now he's going around saying, when I came here this morning, that somehow I prevented him from taping in the past, and that's the only reason he didn't tape. Well, that is untrue. His business is his business. My right comes from the state law that gives me the right to tape. And his saying that I prevented him, like you can imagine anyone preventing Mr. Tersigny from doing anything or saying anything. But the point is, at some point, all this stuff crosses the line. And at that point, with no real reason, you have to start thinking of recalling members or even an entire board, okay? So I just want to throw the idea out there. All you need is 2 people from each building. Okay, that's 22 people to organize each building. And you only need 35 signatures on a recall ballot to accomplish that. So I'd be interested in helping with that, okay, but I can't take the lead because I'm only here for 6 months out of the year now that my father passed away. Okay, so I won't be here from May through October. But I'm here to help if you want it. Thank you very much.
Thank you, Mr. Miro. Bonnie Wolf here? No. Stuart Wolf? Stuart Wolf, 3 minutes, Stuart.
To start with, I'd like to clarify a few things. I sent an email to the board saying that 3 people, including our illustrious manager, Mr. Henry Harvey, our vice president, Michelle, and our president, Mr. Samuels, have made statements that are untrue against me. I offered to debate them before the meeting with the ombudsman being the referee, and let's get the truth be heard. I got one answer from Michelle saying she's too busy to do it and it's immaterial. So, okay, we don't want to do that, but I'm going to back up with Jerry and we're going to have a town hall meeting, and at that meeting I will speak the truth, and anyone from the board is more than welcome to come there. We will not stop them from speaking. And the offer is still good. I will debate the 3 of you alone with the ombudsman being the moderator, so no one could falsify or do anything. Now I've got a few other statements to make. Number 1 is that, Mr. Edmund, since you have taken my place as the treasurer, tell me what our accounts payable is for the month of April.
I'm not taking questions from you.
Okay, so in other words, when you told me you haven't got a clue, you were lying to me. How much money are we going to collect for the month of April, since I haven't gotten a dime? I filled out my form to get automatic pay right away. It is now the 15th. They didn't take out a nickel. I've spoken to a number of unit owners who sent in checks. Their checks didn't clear. So in my opinion, we have 0 money. It is illegal for us to use the money that we have from the insurance claim. So the question is, how are we going to pay? I happen to have a solution, but Mr. Samuels refuses to meet with me or talk to me. The solution is a simple one. There's a company called AFS. We negotiated with them approximately 2 months ago. To make it very simple, they give us 80 cents on the dollar for our collection money. If we had signed the contract